The Illinois Constitution continued. Impairing obligations of contracts. Historically, most laws impairing obligations of contracts were attempted to relieve debtors from their obligations during hard economic times. But this provision has been used most unsuccessfully to challenge other kinds of laws that changed legal relationships after they were formed. The Illinois Supreme Court held that this section did not invalidate the part of the Illinois divorce law enacted in 1777 that made most property acquired by the work of either spouse during the marriage marital property, available for a judge to divide between the spouse if there is a divorce. Nor does it prevent reasonable regulation to protect public health and safety, such as zoning, even though that may interfere indirectly with contract rights. It also does not prevent a law from restricting contracts that are entered into after it is enacted. The Illinois Supreme Court upheld against attack under this section a 1980 law rearranging the revenues and finance of the Chicago school system to avert a financial crisis, even though it might affect the rights of creditors, since it was an apparently necessary exercise of the state power to provide for the general welfare. The Illinois Supreme Court also held that the 1988 Chicago school reform law did not violate this section by ending the statutorily granted tenure of school principals. The court noted that the statutes are not ordinarily read by creating contract rights, since the legislator can change statutes at any time. To establish a contract right from a statute, there must be clear evidence of a legislative intent to create a contract. But the prohibition on laws impairing the obligation of contracts does not bar the General Assembly from directly changing obligations under contract that was entered into before the law was enacted. For example, the General Assembly cannot provide that already issued municipal bonds secured by special assessments that are more than 30 years delinquent are to be canceled, or by new law change the coverage of insurance contracts that were entered into before the law took effect. The U.S. Constitution also prohibits states from enacting ex post facto laws and laws impairing the obligations of contracts. This restricts the state in changing the charters of a few corporations that were given special privileges in their charters enacted before the 1870 Constitution, which forbade the grant of irrevocable special privileges. Probably the most significant example is Northwestern University, whose pre-1870 charter says all of its property is exempt from taxation. But the value of the exemption as to property the university leases out for commercial use has been effectively eliminated by a tax on the leasehold interest in such property, which has been upheld. Retroactive change in civil law. As already mentioned, the prohibition on ex post facto laws applies only to criminal laws, but a somewhat related principle not stated in this section applies to civil law. The Illinois Supreme Court has held that the General Assembly cannot undo judicial interpretations of laws as to the events that took place before the legislative change took effect, thus in effect retroactively amending the earlier law, and in particular cannot reverse final decisions by the courts as to the parties involved in those decisions. These holdings are usually based on the principle of separation of powers, Article 2, Section 1. The reasoning seems to be that if a legislative body could tailor laws to determine the outcomes of specific cases, the power of the courts to decide cases would be, to some extent, taken over by the legislator. Although not usually stated, this argument borders on the principle of equal protection, Article 1, Section 2. Since statutes tailor-made to affect particular cases would tend to be unfair either to the persons they affected or to similarly situated persons they did not affect. However, the General Assembly can amend a law as to future cases. The courts also usually uphold curative laws that retroactively validate actions by government units that were not fully authorized when they were taken, if a law could have authorized them before they were taken and no vested rights or interests are violated. May we have discernment as we figure out and live and apply the Illinois State Constitution under the United States of America's Constitution. Peace, blessings.